All right, let's see if this is working now. All right, you guys in the chat, let me know if you can hear me. Our audio should be on, videos playing, mics all hooked up, all that good stuff. All right, let's see if this is working now. Sorry, I was getting feedback on an alternate monitor. Can hear. Great. Awesome. There you go. All right, guys. We are going to be discussing the court case that just happened. The ruling came down yesterday, and it did not go well. Now, it's not the end all be all. This literally was just the court case in the Second Circuit Court of Appeals for an injunction against the assault weapons ban, etc., things like that. Before I get started, I want to show you guys, obviously, Google. Let me pull it up. I want to show you guys the merch store because we got awesome, cool merch available. You've got the Houthi hunting season. We got hats. We got tinnitus. Let Freedom Ring. All kinds of good things. This is always down in the description below. This is a link to Teespring. I know some people have had problems prior with Teespring. That is why I created an alternate on Bonfire. They've got different shirt, different designs, like Freedom Through Violence. Of course, we do have some repeats like Guns and Ammo. The FAFO one. We got the 556 shirt. And just some other ones. Disabled but deadly. Dead inside but caffeinated. So, you want to support the channel, that is going to be the best way. Obviously, just go get yourself some merch. And I want to give a special thanks. You can see over my shoulder, I do have some boxes of tactical snacks that they sent me. I may or may not be munching on some of these during the live broadcast just because they are absolutely amazing. They are not paying me or anything. I just want to give them a big shout out. I bought their products, and they were kind enough to send me some of their products. It's 3 grams of sugar per bag, 8 grams of protein. They are absolutely amazing. All right, let's get into it. So I have a printout that I'm going to be reading off of, but I will have links for this and the supplement basically coming up here in a little bit. For some reason, all it wanted to show was Google, so you guys did not see all the things I was skipping through. I don't know. That's the technical issue I was having with OBS. All right, so after the live stream, I will have links for all of these things, and I want to give a special shout out to Eddie Grant for sharing these court findings with me, so on and so forth. All right, so what is this about? It was pretty simple. The lawsuit that we have going on here in Connecticut dealing with AR-15s, the Connecticut Other, and things of that nature had pretty much come to a screeching halt in New Haven. It wasn't really going anywhere. So what they did was they, CCDL, Lamont, and a few others, Second Amendment Foundation, created another lawsuit for an injunction dealing with just blocking this law until the court case, which is just kind of petered out in New Haven, is pretty much over and done with. Now, we were hoping while this was making its way through the courts that the Supreme Court would get off their rear ends and basically make a ruling on the overall arch of can we ban AR-15s and guns like it, high-capacity magazines, things like that. So far, SCOTUS hasn't done squat. They have not picked up any of the lawsuits that have come that far. They've either turned them down or just kicked them back down to lower courts, basically saying, hey, based on Bruin, based on Heller, you guys got it wrong. You need to reassess it. And, of course, these cases go down to the lower courts and pretty much die. So while all this was going on, we were seeking an injunction just because, well, Connecticut should not be able to enforce a law that's being currently challenged. So the scope of this goes on to say that before the court are two related appeals principally challenging certain gun control legislation enacted by the Connecticut legislature in the wake of the 2012 mass homicide at Sandy Hook Elementary in Newtown, Connecticut. The Connecticut law issue restrict the acquisition and possession of assault weapons and large capacity magazines. I do the air quotes because they're quoted. We all know assault weapons are not a real thing, and large capacity magazines, that's not a thing. There's a standard capacity magazine, and we have a neutered version of it where we're down to 10 rounds. So it's not high capacity, it's a standard capacity. And I really hate when politicians and lawmakers throw these terms in there, and it really confuses people that really don't know anything about guns. Trust me, we see it all the time. Plaintiffs in both underlying cases are individuals and organizations opposed to those restrictions who would seek to acquire and possess weapons restricted by the legislation, including air platform, firearms, magazines capable of holding more than 10 rounds, so on and so forth. We kind of get the gist of it. Now, all the way down at the bottom, it just says, accordingly, we affirm the district court's denial of the preliminary injunction in both cases. And I could just leave it at that. But the judges on this Second Circuit Court of Appeals went in and gave their opinions. There's a lot of pages, guys. I kind of read through it and grabbed some highlights. You know, in the beginning, John Walker Jr., one of the circuit judges, kind of goes into what happened at Sandy Hook. And I'm not here to rehash what happened. We all agree that it was an absolute tragedy. It was horrible. It lists people's names, things like that. I don't want to do that because, God forbid, the algorithm picks it up and decides to pretty much nuke the channel, or at least this feed. So it just explains like what led up to it. On page 8, they say the Second Amendment protects an individual right to keep and bear arms, but that right is not unlimited. I beg to differ. Sir. The Second Amendment says the right of the people to bear arms shall not be infringed. Done. Deal. Period. It doesn't say that and then with these restrictions. It covers everything. It is unlimited. If you look at the text and you read it as it is, it's black and white. We are supposed to have exactly what the government has, exactly what law enforcement has. I argue that you, under the Second Amendment, could own biological weapons, thermonuclear weapons, and things like that. Because when you look at it, the ATF has a form for nuclear devices. Uncle Sam, our government does not build these bombs. All of our missiles, our nuclear bombs, things like that, are built by corporations like Raytheon and a bunch of others. These are private entities. They fill out ATF paperwork for a nuclear weapon. It exists. I've seen the paperwork. Like on the form, it's an option, like nuclear weapon. So yes, private people, individuals, technically have a right to own this stuff. Now, should they? Probably not. I think it comes down to morals. I really don't want people, having nuclear weapons in their basement and stuff. That is a little insane. But the amendment, the Second Amendment, is cut and dry. The right of the people to bear arms shall not be infringed. Okay? So they go on to say that using tools of history and tradition require the analytic framework set forth by the Supreme Court, District of Columbia, and Heller, and the New York State Rifle Pistol Association v. Bruin. So yes, they're supposed to use those to look at all this. It says, we conclude the plaintiffs have not shown a sufficient likelihood of success on the merits of the Second Amendment claims, assuming the plaintiffs' proposed possession of firearms and magazines at issue are preemptively entitled to the constitutional protection. We, nonetheless, find that the government has satisfied its burden of showing that the challenged laws are consistent with our nation's historical tradition of firearm regulation. The challenged Connecticut laws impose targeted restrictions on unusually dangerous weapons, while previously numerous legal alternatives for self-defense and other lawful purposes. Such restrictions impose a burden comparable to historical blah 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 blah. It just goes on and says accordingly we affirm this. So using history and text, they really like twisted it. It's bad. All right. The burden of unusually dangerous, that has come up a lot. So the Supreme Court has declared, and they said that yes, certain firearms can be banned if it is deemed dangerous and unusual. The state of Connecticut goes on to argue that they can ban guns that are dangerous or unusual. And then they go and explain that AR-15s are dangerous and unusual. So the background, they discuss more Sandy Hook stuff. That's what led up to our, what they call the assault weapons ban and large capacity magazine ban. The big one I took away was on page 11, assault weapons. Broadly, Connecticut defines the assault weapon to include many but not all types of fully automatic and semi-automatic firearms. Its prohibitions apply to select firearms, types of semi-automatic rifles, pistols, and shotguns with military-style features. What the hell does military-style features mean? Various examples of semi-automatic firearms specified by name with military-style features and other commercially available or do-it-yourself copies and duplicates. See Cuomo 804. And it goes on. Take a look at this case. Our non-exhaustive summary focuses on aspects of restrictions applicable to or helpful to understanding the applicable firearms and ammunition plaintiffs would purchase, but for the challenge statutes, a general description of the types of weapons that are restricted assault weapons follow. First, an assault weapon includes any selective firearm both capable of full auto and semi-automatic fire. Okay, stop right there. I beg to differ. That is the definition of an assault rifle, which is a thing. It's always been a thing. It's been a thing since World War II. An assault rifle is select fire. You can be on safe, semi-automatic, full auto, or burst. Okay, it's either full auto or a burst. When the M16 first came out during Vietnam, it was safe, semi, full auto, and they noticed that soldiers were just praying and spraying. So they got rid of the full auto and they went to burst, basically, because they were just burning through their ammo. Which is nuts. Today, yes, the military does have full auto capabilities, obviously on their service firearms, their service rifles, but they're very, very, very rarely ever used. These are usually used for suppression, and that's why we have a saw. You're trying to bound, you're trying to flank the enemy, things like that. But it is beat into your head in the military that you pretty much shoot in semi-automatic only. Aim, shoot, etc. This way you can aim at what you're trying to hit. You fire a round, either hit it, you don't, and keep doing that. You don't just go to full auto and just dump all your ammo. Remember, it's not a video game. You are limited to the amount of ammo you have. Once you're out, you're out, or you're trying to bum ammo off your buddy. Goes on to say, a long-time issue rifle for the United States military, the M16, and its successor, the M4 carbine, are representative of a select firearms qualifying as assault weapons. No, they're assault rifles. I really, really hate people that write things about guns and they have no idea what they're talking about. Second, an assault weapon includes any semi-automatic center fire rifle that has 1. The capacity to accept a detachable magazine. 2. One or more of the 5 specified military style features. Any one of these satisfies a 1-feature test. This is coming out of the Connecticut General Statute 53202A. The Bushmaster XM15-E2S used in Sandy Hook was an other AR-15 style rifle. The plaintiffs would seek to purchase and possess are a representative example of semi-automatic center fire rifles qualifying as an assault weapon. Assault weapons, again, aren't a thing. I mean, you literally ask any politician to define an assault weapon, and they can't. They usually give a roundabout answer, or they describe something exactly what the military has, which I hate to tell you, that's not what you're going to own as a civilian. That being said, given the right paperwork, you can literally go. I mean, if you're an SOT, you could literally buy a machine gun and have it in your inventory. That's just the way it is. But you have to be an SOT. You, as a regular person, can't just do that. So they talk about the centerfire rifle, blah, blah, blah. Again, I'm going to put this down there. Third, an assault weapon includes semi-automatic rimfire rifles that has the ability to accept a detachable magazine, 2 or more of the 5 specified military styles. None of our laws touch rimfire. 22 LR, you can still have a detachable magazine. I don't know why this is thrown in there. Fourth, an assault weapon includes numerous specified semi-automatic firearms identified by make and model. And they're copies or they're duplicates. So we know that Connecticut went through and they listed a whole bunch of guns by name, which that was part of the original assault weapon ban, which gave birth to the Connecticut other. And they go on to say the 2023 assault weapons ban. In 2023, Connecticut further expanded its definition of assault weapon to include any semi-automatic firearm other than a pistol, revolver, rifle, or shotgun, colloquially called an other. So we all know that the other, or the Connecticut other, was basically your standard lower, standard upper, but instead of having a buttstock on the back, we had a brace, and on the front, we had a vertical foregrip. That was legal according to the ATF. Connecticut banned it in 2023. They call it a loophole. Not really a loophole. We were being compliant. They just didn't like how we were compliant. They go on to name 7 specific military-style features, any of which can satisfy this test, so on and so forth. It's consistent with Connecticut law to refer to those other unidentified firearms with one or more of the specified military features as the 2023 assault weapon. Prior to 2023 amendment, there was a loophole in Connecticut's regulatory scheme. It is a regulatory scheme. Connecticut's reliance on applying for varying 1 or 2 feature tests on a firearm was met with a statutory definition of a pistol, revolver, rifle, and shotgun. And they just ramble on about other things. Stuff that's not really pertinent to what we're here to discuss. I want to get into the discussion. Some things that kind of irritate me while reading this. Under their analysis, the Second Amendment of the United States Constitution provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. U.S. Constitution Amendment 2. Over the course of the last 2 decades, the Supreme Court has issued 4 opinions that principally inform our understanding of that command. We summarize them with Heller. The court announced the first time the Second Amendment confers an individual right to keep and bear arms. You guys got to remember, prior to a lot of these SCOTUS cases, decades ago, like 20, 30 years ago, a lot of states didn't issue gun permits. You had no right to bear arms as you think of it as today. We have made great strides with court battles and getting the Supreme Court to actually tell these states, this is what the Supreme Court, or this is what the Second Amendment means. Cut and dry. There was no room for interpretation. So they go on and explain Heller. And they just go in depth about, the court in Heller made it clear that the right was not. They said it was not unlimited. Yes, that's right. They did. They used the dangerous and unusual argument that certain guns could be banned if they were deemed dangerous and unusual. Okay. I know you guys love watching me flip. I'm just going to get to the main points. Preliminary considerations. This is going to be on page 28. We begin our analysis by discussing three concepts, as to each of which the parties have offered compelling interpretations that guided their analysis. Number one, common use. Plaintiffs insist that challenge restrictions on the desired firearms and magazines violate the Second Amendment because they are categorically ban on widely popular weapons in common use today for lawful purposes. This is what Grant v. Lamont was arguing. Plaintiffs contend it's sufficient for a finding that possessing regulated weapons are protected by the Second Amendment, blah, blah, blah. So the judge says that plaintiffs, which would be Eddie, distort their argument and relies on Heller v. Bruin, provide the Second Amendment protects only the carrying of weapons that are in the common use at the time, such as pose. And it just goes on to explain it. They do not shield popular weapons from review and potentially unusually dangerous character, blah, blah, blah. It's a lot of words they've thrown in. All right, dangerously unusual. This one really caught my attention. It's on page 29. The Supreme Court has recognized a historical tradition of prohibiting the carrying of dangerous and unusual weapons. This was said again in Bruin. Defendants argue that the challenged status fall within this tradition. Plaintiffs and their counter in this limitation of the Second Amendment right applies only to those weapons that, unlike AR-15s and large capacity magazines, are both dangerous and unusual. We conclude, however, that the historical tradition encompasses those arms that legislation determined were unusually dangerous because of their characteristics. That's what the courts say. That we can ban these because they are unusually dangerous because of characteristics. Not function, not what they're chambered in, but their characteristics. So basically how it looks. Our understanding of the Second Amendment is informed by history. And it goes on to talk about Bruin. Historical prohibitions on affray, both the formulations dangerous and unusual, and dangerous or unusual, which was never what they intended. It's not dangerous or unusual, because with that mentality, you can just deem anything dangerous and then we could ban it. It had to be dangerous and unusual. So that would be somewhat like, well, we'll go into like a nuclear weapon, a biological weapon, or something like that. Not everybody has it. Not every country has it. They are dangerous and they are unusual. There are not millions of them out there in the public. They are regulated and held onto by the government and things like that. Goes on to talk about Blackstone defined the offense of a fray in the act of riding or ongoing armed, dangerous or unusual. No, it was dangerous and unusual. And it just keeps talking about Bruin. They go on to say that they understand that AR-15s are unusually dangerous. They're not. Plaintiffs challenged our unusually dangerous interpretation by pointing to concurring Supreme Court opinion characterizing the exception as a conjunctive, dangerous, and unusual test. And they just talk about how they disagree. Interest balancing of the people. The Supreme Court was made it clear that like most rights, the right secured by the Second Amendment is not unlimited. Heller, historically the right was not the right to keep and carry any weapon, whatsoever in any manner whatsoever and for whatever purpose. Now, you'll hear in the media, famously said by Biden, that you can't own cannons. Well, listen, you can. It's in the founding documents. It's in. Madison wrote about it because we had privateers, and they said, "Hey, you got the Second Amendment. Does that mean we can have cannons on our ships to protect our shipments?" And in the Federalist Papers, Madison said, "Yes, you can always have cannons." All right, so we had armed ships off the coast of New York, Connecticut, all that since the 1700s, and it was fine. Fast forward today, just a couple of years ago, you had the president on TV talking about how you couldn't own cannons, they were illegal, and, well, it took me 5 minutes, a quick Google search, to find a very large cannon that you could purchase and have it shipped anywhere you wanted to, because it is technically not a firearm by law. So, he was wrong. And I know a lot of people in the media ran around with that, like, you can't own cannons. It's like a quick Google search and you can. I don't know. Skip all the way to page 55, and they come in sum. We conclude that the defendants have, at this preliminary stage, satisfied their burden to demonstrate that permissible historical arms regulations that single out the unusually dangerous weapons of their day are relatively similar. At the same time, both the historical and the contemporary legislators did not impair the Second Amendment right to be self-defense by allowing many weapons to go unchecked. The less than absolute right codified by the Second Amendment permits Connecticut legislators to honor the constitutional balance captured by its text, as interpreted by the Supreme Court in light of history. The Second Amendment thus allows these legislators to do what they did here: implement targeted regulations designed to protect residents and their children from experiencing tragedies like that of Sandy Hook Elementary School. So they're using that and the children, something that's still raw to us, as justification for shooting down our lawsuit on an injunction. They're just like, yep, nope, sorry, you can do that. They're dangerous and unusual, which they are not. If you look at how they work, they banned ARs, we came up with the other. They banned the other, we now have Fight Light SCRs, which are just AR mullets. It's like M-lock rail up front, normal receiver, and then you have a proprietary lower, and it's all FUD in the back. It's a hunting stock. You can have a removable magazine. It can be chambered in 5.56, 300 blackout, and there's other calibers out there for it. And those are perfectly legal. Wow. It's the same damn gun. Okay, in here, I know it's in here, I read it, but I kind of think I shot past it. They literally compare the AR-15, saying it's okay to ban that because we have access to Mini 14s, which are virtually the same gun. The Mini 14 it's virtually the same gun. It's got a wooden stock. That's it. It's got a wooden freaking stock. They're chambered in the same damn round. I don't know. Then there was a supplement that came along with it from one of the other circuit judges that joined Livingston, the chief judge, and Walker, who wrote the original I'm drawing a blank on it. The original discussion on why Connecticut can ban what it wants. So that's it. They just said, hey, they can do that. I don't know what to tell you. I I think our courts are just screwed up. The only good news is, the only saving grace, I did see on the news this morning that while our Second Circuit Court was shafting us, the citizens of Connecticut, the courts down in Tennessee found that their clause they have in the general statute saying when you carry a gun, you can't carry a gun with the intent to carry. It's weird. They tried to vote that little phrase out of the state's general statute earlier in the summer, and it didn't go anywhere. The courts yesterday, today, somewhere around there, found that that little phrase right there, intent to go armed, is unconstitutional and must be stricken. Tennessee also had a general statute on the books and said you had no ability to carry in parks with the intent to go armed without a permit, things like that. That was also struck down as unconstitutional. So there's some wins there. Unfortunately, it's not our wins. They're not Connecticut wins. I know a couple other channels, like the Lock and Load podcast, covered this a little more in depth. Instead of me sitting here just reading tons of legal mumbo jumbo, I can sum up the whole thing. We got shafted. We got screwed. So there you go, guys. Welcome to Connecticut, where the Second Amendment has come to die. And what I really ironic is the state's constitution is older than our constitution for the government, for the federal government. And in the Connecticut Constitution, we have an amendment that literally is identical to the Second Amendment. You have a right to keep and bear arms under Connecticut's Constitution, which they largely ignore. Of course, the Second Amendment is in our Bill of Rights, and the state of Connecticut does not care. They interpret it differently, things like that. And they go back, they do mention a bunch of cases. This is what really drove me nuts. They mention cases and refer to certain cases that, like Antioch, that had gone to the Supreme Court because they were in the lower courts found them, they found the wrong way. So they appealed it to the Supreme Court. The Supreme Court looked at the case and said, nah, we don't want it, and just kicked it back down and told the lower courts, you ruled wrong, you need to look at it again. Those courts are just dragging their feet. Those cases are not going anywhere. So the original finding, which is unconstitutional, gets to stand until the courts reassess what was kicked back down to them. So the Second Circuit referred to a lot of these cases as justification for not giving us our injunction. The Supreme Court, in my humble opinion, needs to get off their ass and finally take one of these cases that deals with AR-15s and that style and what they deem as large capacity magazines, and just give us a final ruling that covers all states. Is it constitutional or is it not? And if it's not, then all these laws would go away. But for some reason, the Supreme Court is just full of cowards, and they are not willing to pick up one of these cases. Time and time again, we see the cases go before them, and they just get kicked. It's kind of disheartening. I know this last time that they refused to take a case. In the dissent, they said that they plan on taking a case in the next year or two. The problem is some of our favorite Supreme Court justices are aging out, and unfortunately, they might not be in the Supreme Court when the court finally decides once and for all they're actually going to take up one of these cases dealing with ARs. So it's just one of those hurry up and waits. I don't know what to tell you. I think we're just getting the raw end of the deal here. I'm going to take a quick look at your super chats, or just chats in general, see if there's anything going on. Chewing Bubblegum says Lamont sucks. Yes, Lamont sucks. Very much so. Listen, guys, we have an election coming up next year. If Lamont wins again, I don't know what the hell's going on. We need a better candidate for the Republican Party. Right now, there's a few, but I haven't seen much coming from them. My question is, though, what is their stance on the Second Amendment? A lot of them just beat around the bush. I don't know what to tell you. It's the Northeast, guys. Lost cause. I think it's time for us to escape. With that being said, if anybody lives in Southington, good friend of mine, Josh Serafino, is running for city council. So if you live in Southington, that's who you need to vote for. Vote early, vote often. I'm kidding. That's a joke. All right, I'm just kidding. But that's where I asked, can people hear me? All rights are unlimited, even speech and religion. This is from Matt Altieri. I would beg to differ. Freedom of speech is not regulated. And don't give me that whole, you can't scream fire in the theater. You can. That is perfectly legal. All right, you have the right to free speech, but you also have to suffer the consequences of that free speech. If there were an actual fire in the theater, I would hope somebody screamed fire. It's not illegal. Sorry. It's a stupid trope that, yes, at one point they said, yeah, it's illegal, you can't do that. Then the Supreme Court, years later, said, actually, you can. Freedom of speech is freedom of speech. That's how come people can say some of the dumbest things. Look at Westboro Baptist Church. When they were back in the heyday, when they were saying all their dumb stuff, did I agree with any of it? Not a single word. Did I support their right to say dumb shit? 100%. It showed you what kind of people they were. They were bigots and racists and sexists, etc. And I'm glad they got to say out in public how they really felt, so we knew what kind of people they were. Shall not be infringed actually means unlimited. Yes, chewing bubblegum. It does. It does. Supreme Court just take a case. The en banc and something just come up in October. Bill Poole said that. Matt Altieri came back. The case will never get anywhere. If you're talking about Connecticut case dealing with ARs, nah, it's stuck in New Haven. It's not going anywhere. Chewing Bubble will get some income and use. So any bans are illegitimate. Yeah, pretty much. Here's the kicker, though. We just passed, well, not we, but the politicians, just passed HB 7042 a couple of months ago. In case you didn't know, one of the parts of it, and I've covered this, specifically says that it is unlawful for an FFL to sell any firearm which is knowingly, easily converted into something illegal. And that's pretty much all it says. It's very ominous. So we don't know what it means. They're not explaining what it means, but we brought up things like, okay, with that clause in 7042, a Glock 19 could easily, illegally be converted to full auto with Glock switch. Do we have to stop selling the Glock 19? Couldn't answer that. You can go to an FFL today, anywhere in the state of Connecticut, and you can buy a stripped lower. It falls under the other category, and it's perfectly legal. Now, the way the statute works is you're supposed to be, you're going to build yourself out a fixed mag, you're going to build out yourself a bolt action, or a dedicated 22 LR. Those are your options. The FFL sells that stripped lower to an individual, and that individual goes home and they just build out an illegal SBR. Based on 7042, the FFL sold a firearm, because the lower is the firearm, to an individual knowing that it can be converted into something illegal. That SBR, technically under Connecticut law, is illegal. But what's the FFL supposed to do? Once the gun has been transferred, it's out the door. It is not the FFL's job to ensure you, the owner of said firearm, complies with the law. That's not their job. They have no authority. So the state is just trampling all over your rights, guys. Bill Poole, let's hope at this point, maybe after Bruin, the lower courts that have been ignoring them and need to be set straight shall not be infringed. Unfortunately, Bill, these courts, either they're going to sit on it, or an en banc panel is going to just grab it and just say, yep, it's good, leave it alone, and it's got to work its way back up to the Supreme Court. Chewing bubblegum, do not comply. Okay? So, here's the problem with that. And just hear me out. HB 6667 was passed. Everybody that owned an other or had lowers had to re-register their guns with SLFU to get your assault weapon certificate. Now, when we bought them, they were registered with the states because of the DPS 3. So SLFU knows exactly what you have. We had to go back in and re-register them in the portal. Did a whole video on it. There were 3 types of people out there. There were people, much like you chewing bubblegum, don't comply. Okay, fair enough. There were those that complied without hesitation. I had my issues with it. I didn't want to do it. I freely admit that. But after having a lengthy conversation with a few lawyers in our state, they did point out the fact that I would be the first one that would be arrested and made an example out of. So I complied, and I made a whole video on it. The third camp were people like Heather. Remember I covered Heather? Single mom, Plymouth? Who had no idea this law passed. And, well, she got hemmed up. They've done the pretrial. Her court case is until, I think, next month. So I know some of you are looking for an update on it. Unfortunately, there's not much to update. Once I know something, you'll know something. I'll cover it. Hopefully, we hear something soon. So I know you're saying don't comply. They'll hem you up. Now, we did go after an injunction on this whole thing. And from my recollection, and I'm probably slaughtering this, the state's attorney basically said there's no proof that they would ever enforce this aspect of the law, the assault weapons re-registering, as in if you don't register it, they come after you. They said that's not the point. They're not going to do that, blah, blah, blah. Fast forward to today. Heather, that's what they did. They picked her up, and I don't want to see in the comments all the other stuff aired out about personal life. I care about the one damn charge. Illegal possession of an assault weapon, which, when you read the law, is supposed to be, if your first offense, it is a Class A misdemeanor. The state is using that legal jujitsu and the power of the state to crank it up to a Class D felony. That's at least a decade in jail. They threatened to take her kid away and things like that. So even though they told the courts, we're never going to enforce it, they're enforcing it, guys. So for people that are like, don't comply, buckle up. Nobody's rights are violated. That's what Matt Altieri says. You're violating my rights if you tell me I can't own something. Sorry. It's so stupid. Oh, YouTube just jumped on me. Diesel, our friend from USCCA. They're not dangerous or unusual. They're a firearm and they can't work on their own. Correct. The only firearm I know that can work on its own is the P320. I just had to throw it out there, DC. I had to. I had to. Yeah, didn't you see the short on my M17? It's a mini goat gun and it still went off. Criminals can own whatever they want in Connecticut. Yes, chewing bubble gum. That, sir, is what I point out when I teach my basic pistol safety course over at Lock and Load if you are in need or know of anyone in need of a basic pistol safety course. Take a look at Lock and Load in Southington. They run courses every Saturday and Sunday, sometimes on Tuesdays and Fridays. Take your class there. If you already have your Connecticut pistol permit and you are in need of a multi-state permit, such as Massachusetts, Florida, or Utah, Lock and Load in Southington is also a great place to take those classes. They've got one tomorrow night, multi-state. So if you're needing to pick up your Utah, your Mass, or Florida, hey, you might want to check them out. Bill Pool. We're making changes now that are impossible a year or two ago. You know? Chewing bubble gum. SCRs and Mini 14s will be banned next. Don't put ideas in their head. Guys, don't put ideas in their heads. Chewing bubble gum. Banning threaded barrels on pistols and other stupid asinine restriction. Yes, it is. Yeah, that's why I joke about it in class. I'm like, in today's class, when we go to the range, we will be using an assault weapon for qualification. And then I bring it in. It's a small 6 Sauer P322. But by the definitions that Connecticut provides, it's an assault weapon. Why? Because it has a threaded barrel. You can't have a threaded barrel on a handgun because they don't want to accept a suppressor. But, that being said, if you screw on a quick disconnect on top of those threads, pin it, and spot weld it, now it's legal. 100% legal. It will now accept a suppressor. The only drawback is you're never going to get the barrel out of the slide. It's just never going to happen. So that's just your trade-off. It's just making cleaning it kind of a bitch. And you can't take the barrel out. So if you ever have a massive barrel problem, you're kind of SOL. That being said, how many of us have really had a massive barrel problem that have prevented us from ever using that barrel again? So it usually doesn't happen. Jessica, right, so much for the constitutional state. Hey, it's not the constitutional state. We're the unconstitutional state. I know, in the merch store we have shirts that say it. It's got the Connecticut flag upside down because we are in distress. Commie Connecticut. Yep. I do find it amusing that historically speaking, Connecticut was the state where the finest firearms in America were made. Colt. You had High Standard, Marlin, tons of companies, and they've all left. They're gone because Connecticut just drove them away. Corrupt kit fits at this point. Yeah. Connecticut State Constitution, Section 17, every citizen has the right to bear arms in defense of himself or the state. Yes, that's called the militia. It was made of the people to defend the state. But Connecticut chooses to ignore that. And when you do mention it, politicians are like, oh, harumph. That does not matter these days. So you need a SIG drop safety t-shirt. Yeah, I might be able to do something like that. Well, that's it. That's pretty much all your chats, guys. So, I know I was a little late, but I was having technical difficulties. So, that is why I was a wee bit tardy. So, I figure right now, you know what we could do? Unfortunately, I still have this. McNasty has never gotten a hold of me. Bro, McNasty, you won this. Bro, you got to reach out to me. I have literally commented on your comment. I have pinned a comment. McNasty, where the hell are you? You gotta write to me, man, so you can get this. All right. This one, solid black. Just like the ones on mine. It is for the Glock 19, the Glock 23, the Glock 25, Glock 28, and Glock 32. Throw your comments in, guys. Do something. That's the only way I know how to pick somebody. So you put in comments. That's it. Doesn't have to be a super chat or anything like that. I'm going to let this run for 1 full week. So today is the 23rd. So I am going to let it run till the 30th. Everybody that throws in a comment will be put into a drawing for this. And y'all need to pay attention. I will respond to your comment, and I will make a post, and I will pin your name in there. Reach out to me, and I will send it to you. All right. On top of that, to sweeten the pot, this Glock rip, let's go through this little bag right here, and I'm just going to randomly grab something in here. Let's see what's in there. We'll grab a nice little patch. These patches, this one is from globalordnance.com. It's a mortar round. It's got a Wilson on it, little Wilson handprint. I will throw that in with the Glock grip. So these right here, both of those. Got these down in goals. So some of these patches are a little hard to get. All right, so hit up the comments. 1 week, and I will send those out to you, so on and so forth. Let's see, there's more chats coming in. I'm surprised Colt's still here. Yeah, but they don't do much here. I mean, they do make ARs at one of their factories, but they're not for us. They're more of the military contracts. Jessica, I can pretend to be McNasty. No, McNasty needs to reach out to me to get the checkered ones. I'll give McNasty, what do you guys think, a month? A month from today? So, September 23rd, if McNasty doesn't reach out to me, we'll put him back in the drawing. Checkered ones. The insult to injury, the peasants can't own what's made here. Yeah. What's insult to injury is I'm a Connecticut resident and I can't own half the stuff I want. When we were down at Goals, we're looking at all these awesome things from the manufacturers. Can't own any of them. But Mrs. Guru is a Tennessee resident. Mrs. Guru gets to own all that stuff. So if she wants all that good non-compliant stuff, she just goes to Tennessee, picks it up, and stays down in Tennessee. That's not fair. I can't believe they didn't try to ban burgers here yet, since it is a Connecticut invention. Yes, it was invented in New Haven in around 1900. It's up for debate. It's up for debate. Can't the states override the Supreme Court's rulings? No, Thomas, they can't. Once this, it's in their title, Supreme Court. Once they lay down the law, that's it. Otherwise, every time they laid down a ruling, insane states would just ignore them and do whatever the hell they want. It's part of the supremacy clause. Right? Remember, we have 3 co-equal branches of government: the legislative branch, the administration, which the executive branch, and then the judiciary branch. When the Supreme Court makes a ruling, that's it. Done. Now, the Supreme Court can undo their rulings, which they pretty much did with abortion. They just said, yep, we're wrong, and gave it back to the states where it belongs. So states can make up their laws according to what the constituency wants. Should never have been at the federal level. Even justices that you never would think said, yeah, it's a bad ruling. And if you don't know who I'm talking about, be Ruth Bader Ginsburg. She didn't agree with it. She thought it was bad. She said at some point it will be overturned. It should have stayed with the states. And I agree. Let's see, Jesco. Oh, man, I skipped a bunch. I'm sorry. So we had so many gun manufacturers in the state at one time. Yeah, people having too much boating accidents in Connecticut. Yeah. A lot of people had boating accidents in Connecticut. Malcolm. So the states' rights don't apply in that case. You're talking about the 10th Amendment. So whatever isn't designated to the federal government falls upon the states. The Constitution is federal. The Bill of Rights is federal. If the Supreme Court comes out and says the Second Amendment is absolute, then no state can pass any law because the U.S. Constitution trumps it all. You can't have states going rogue. 10th Amendment refers to things like the state gets to decide how they run their elections. The state can have tolls or not. The state can do a lot of things that the federal government doesn't have the ability to do. Over the decades, the federal government has gathered and accumulated more powers than it was ever designed to have. That's a problem. Let's see if the state... Oh, I read that one. Let's see. Damn, I'm late. Pete, you're not late. This is being recorded. As soon as I shut off, you can always go back and watch the whole thing. I'm late to the party. I didn't know anything about this law. What are my options? Mr. Binda, or Ms. Binda, I don't know. What law are we discussing? 7042, HB Satan 7. What law are you asking about? Switch residence to Florida from Connecticut. You should. Become a Florida resident. Unfortunately, whatever you can purchase in Florida, you won't be able to bring back to Connecticut because as soon as you cross the state line, it is a felony. It would have to stay in Florida. So what is stopping the state from not recognizing the 19th Amendment? The federal government. Federal government, straight up. So Satan 7 being overturned. Parts of it would be. The other. I mean, there's a bunch of stuff in HB Satan 7. Only small parts of it would be overturned. So including in HB Satan 7 is the way we conduct our classes. One of the things that we must include now are Connecticut state laws. That was part of HB 6667. That wouldn't be overturned. The state requires a permit because they have a permitting scheme, and they regulate how the classes are taught. It's that simple. That part would not be overturned. So the entirety of HB Satan 7 would not be overturned. Just the part where they banned others and other guns like it. Remember when I bought my first rifle in upstate New York? The permit scheme is unconstitutional. Yes. Please add me to the drawing for the Glock grip. Hey, you know what? You made a comment, and that's good enough for me. So, all right, guys, it is 10 after 8. I've literally ran for 1 full hour. Just to kind of sum everything up, nothing changed. We were looking for an injunction, and the court said, nah. The state can continue to ban these things and make this, that, and the other thing illegal, and it's constitutional, and based on these cases and this and that, the biggest takeaway was the AR-15s are dangerous. or unusual, which gives the state the right to ban them. I'm sorry, but it's supposed to be dangerous and unusual. Both of them have to be met, not one or the other. The state of Connecticut doesn't see it that way. They said, nah, or. There's a huge difference between and or. And the state prefers or because, well, they can deem anything they want dangerous. So, that's the way it is. I'm waiting to test my Glock grip. There you go. All right, guys, you have yourselves a wonderful evening. Go enjoy your Saturday night. Don't watch me ramble on and on and on. I'm going to go hang out with the fam and go relax. I do have to teach a class tomorrow. Don't forget, tomorrow evening at Lock and Load is a multi-state class. So if you're in need of Utah, Florida, or Massachusetts course, go to Lock and Load's website. Take a look at it. All right, they run classes all the time, guys. You know how to reach me on my website if you need a private lesson, anything like that. And in the meantime, I will holler at all of you later. You guys have a great evening.